Welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be taking up the 3 o'clock riveting testimony in the Rosenbaum case. The medical examiner on the stand. Let's go to court. Okay, welcome back to the Law and Crime Network. I'm Bob Bianchi. Great opportunity, as it would be, to bring in my two great guests. As you guys know, as always, my bestie, Gene Rossi, hashtag 4041, 30 years at the DOJ, an unbelievable trial record. Welcome to the show.
Good afternoon. Good to be back.
Okay, and right from Georgia, freshly minted here, her first appearance in studio at the Law and Crime Network, Ashley McMahan from the Law Ladies. I was looking up this bio. I love it. Everything about your bio is Georgia, Georgia, Georgia High School, Georgia College, Georgia Law School, Georgia great awards. You were in the Georgia District Attorney's Office where you prosecuted thousands of cases and have an incredibly successful trial career. Welcome to the in-studio version of Law and Crime.
Thank you so much, Bob. It's great to be here.
Okay, awesome. Guys, let's start with something that Ashley and myself are talking offline. Gene, having prosecuted many homicide cases, I cannot think of one where I put the forensic pathologist on as the first witness. Actually, to be honest with you, many times I buried them in the middle of the case because the mechanism and cause of death were clear. Why wasn't in this case, however? I do a little bit of a different thing here because of the manner in which the defense is positioned in this case. Why wasn't this person the first witness called?
You know what? I don't know why, because she's pretty good. And I heard you and Ashley talking. She adds a little zest and vitality to the case, unlike some forensic pathologists you folks have had where, you know, you want to take a little daytime nap. So I don't know why they didn't start off her being the leadoff hitter in the top of the first inning. Yeah,
Gene, Ashley, that's what I used to call wanting to put a knitting needle in your eyeball when the person is testifying because you feel like killing yourself. But you brought out this point, and I was thinking the same thing. This witness is basically saying these injuries that we're talking about, these are not consistent with an accident. The ear injury is consistent with either pulling or forcefully, and these other injuries are consistent with abuse. Thoughts?
I mean, Dr. Laura Darasaw doing an amazing job here, just coming in and absolutely destroying the defense's entire case. I am also shocked that she wasn't put up very early in this case because I think you kind of have a slam dunk for the prosecution after her testimony. Every other witness's testimony in this case should have been used to back up this forensic pathologist's initial testimony.
Yeah, Gene, to Ashley's point, and we talk about this all the time, and you train so many prosecutors as I have, this is the way you go about it. Just like Ashley said, she tees up every other witness, then the jury can put into context, look at all these crumbs that are leading up to this eventual death that the pathologist talked about. I agree. What do you think, Gene?
Oh, absolutely. And as you both know, that when you present a case, if you have more than a couple witnesses, you try to present them in a tactical and strategic order so that each building block makes sense as to why you're calling the witness in this particular order, unless you have work issues or things like that, vacation. But she's pretty good, I got to say. The punchline is she's pretty darn good.
And Ashley, we always go into our chat room, and because they're our second jury, I always say that if I'm ever trying a case that's profiled on the Law and Crime Network again, I'm hiring somebody just to look in the chat room as to what these folks are saying. They think that she's a tremendous witness. And like we talked about before, sometimes when you're preparing your case, you got to look at who the strengths of your witnesses are that are testifying. She's got it all. She sets it up for all the other witnesses, like you said, and she's very entertaining in the manner in which she's delivering it. I mean, funny, but we were looking at it like, oh my God, that's really, really interesting testimony.
Well, I mean, the bar is very low for a forensic pathologist to be funny or entertaining on the stand, usually as long as they're not, like you said, boring the jurors to death, or you don't have a couple of jurors taking a nap. That's a huge win. But in this case, she's going beyond the four corners of the document, of her report in this case. And like we were discussing before, that's an amazing thing to have your pathologist do. And I think it's a big win for the state on this, and I don't know that they're utilizing this witness as much as they really should have in this case.
Ashley, I want to pick up on that point you just raised, the four corners of the report. And I've had this before, where the pathologist refuses to do anything other than say the basics and the science, and that's it, but they don't want to draw conclusions. Yet I've had other pathologists who really give you insight into the mechanism of the injury itself, and their testimony can really, therefore, be profound as a prosecutor, of course, if it supports your case.
Right. Well, I think in this case, or in most cases where pathologists refuse to go beyond the four corners of of the document, it's because they're afraid of raising an objection from the defense, which oftentimes happens. It doesn't seem like that's what's happening in this case. And so I think, you know, Dr. Laura's just kind of going with it and seeing how far she can push. And she's doing a great job because I think she knows exactly what happened to this poor little girl.
So, Gene, to Ashley's point there, she tees up another great question. She's doing a great job already in studio, Gene. I don't know. She may become my next bestie, Gene.
Yeah, well, I'm not happy with her because her Atlanta Braves beat my Nationals last night.
Well, you know, listen, with all the flirting you've been doing with Linda Kenny Bodden and all the other Jesse Weber, I don't know. I'm just thinking that maybe my Georgia girl over here, I mean, the law ladies, it'd be a nice little compliment. But anyway, Gene, seriously, to her point,
yep.
These are like doctors who don't want to go beyond the four corners. Why is the defense not objecting to this? I don't think it's bannable, but do you think that they at least try to throw a little interjection in there to try to shake it up, or are they just saying, let's just pass this and move on?
Pass this and move on, because, you know, you talk about the four corners of the report. The court and a witness does have discretion to go a little bit beyond those boundaries as long as it's consistent with the punchlines of the report. But if I'm the defense attorney, you know, I'm not gonna do a destructive cross of this witness. It's not gonna do anything for their clients.
Sometimes you got to know when to fold them and know when to hold them. Gene Rossi, Ashley, we'll be back. We're going to do some business here at the Law and Crime Network. Don't go anywhere because this fascinating witness is still on the witness stand. Okay, there you go. 911 call. Ashley, well, you're listening to that as you as a lawyer. You want to listen to it like a juror first. And you're listening to that as a juror/lawyer. Are you persuaded that she is somebody that was in the midst of an emergency, or is this some masterfully concocted story to help her get out of trouble for having harmed that child?
I got to be honest, looking at this just as a juror, as a layperson, somebody that doesn't necessarily know the law, looking for the emotion in her voice, it just doesn't sound like somebody who's got a child that is potentially choking to death. You know, she even goes out of her way to say in the beginning of the description, I've got a toddler here, and then she goes, oh, wait, foster child. And she makes that distinction, which I thought was interesting. Any mother in the middle of an emergency with a toddler is not going to wait and make a distinction on whether or not this is her child to an emergency responder if you're trying to get an ambulance to the house. That just doesn't make any sense. You know, I'm worried that I may have broken a rib. I don't know how to do this CPR. However, you know, it doesn't look good. She's breathing, but it doesn't look good. Again, it just doesn't sound like somebody who's in the middle of an emergency. Yeah,
interesting, Ashley. You're the first person that brought out that little permutation about the foster care scenario. Right. Gene, does that persuade you? When Ashley said that, is that something as a prosecutor you would be bringing out in summation?
Ashley's a machine. I totally agree with her. That foster thing, I didn't even think of that. The rib thing, and you're going to get a jury instruction, I'm sure, on false exculpatories. And this 911 call, I don't know how many minutes it is 100% false exculpatory, because you don't hear in her voice that quiver, that nervousness, that sense of trauma when your child's about ready to die. It seems very antiseptic.
Yeah, well, so that's another one that Gene Rossi, what did you say, that Ashley's doing what?
She's a machine.
She's a machine. Okay, so I'm asking the chat room, should I abandon Rossi since he's been flirting with all those other hosts and make this my new bestie? Let me know. Kit, do the tally. Should it be Gene or Ashley? Okay, look, great commentary by both of you guys. Love having you on. But the 911 call was not the only piece of pivotal evidence in the case. It's important to also understand that the medical examiner, who is still on direct examination, now watch this, watch how this came together, starts talking about what was described by the mother on the 911 call vis-a-vis that it sounds more like a seizure as opposed to a choking event. Let's take a listen. Okay, so, you know, Ashley, that's the sister. I'm not sure how compelling his child, a cute kid, you can just tell, right? The interviewer doing a very good job. And let's talk a little bit about how interviewers have to be very careful that they don't suggest answers to a child at that age. And by the way, the kid apparently is looking at some news accounts or knowing something about the facts of the case, which is never good for a prosecutor.
Right, and you know, this is a problem that comes up frequently with young children that are going to testify in cases of this magnitude. First of all, you have to worry about the fact that she she may have suffered traumatic events while she was in foster care as well. You know, so you've got to be careful when you're dealing with that. That's why we're doing an audio recording of her interview, because she's giving this interview somewhere in a safe space, probably, you know, with 2 interviewers and with a bunch of toys around, and they've made her feel comfortable. But you can even hear in some of her answers to her questions, Miss Jennifer pushed the food down with a knife. Well, how do you know that? Did you hear the news about her? Clearly, this child, I mean, it's taken a year to, you know, get this case to trial. Of course, she's going to have heard things, and it's hard to tell what a child has just heard from other people, from family members, from the news, just talk around her. They're like little sponges. They absorb all this information, what she's heard and what she now believes is something that she may have actually seen but didn't really occur. So you got to be real careful with these types of witnesses.
Yeah, agreed, Gene. I think the best thing about her is the injuries, the physical injuries that support the state's case. But to Ashley's point, and I think it was the seminal case on this was the Margaret Kelly Michaels case. It's referred to as a Michaels hearing. It was out of New Jersey, where a number of kindergartners, I believe they were, came forward about sexual assault allegations of Ms. Michaels that were later determined to be untrue. And it was striking the manner in which the interviewing took place suggested to the kids answers. And they were so consistent, and there were so many of them, everybody just assumed, well, Ms. Michaels must have done this, until it was later determined that she didn't. And they came up with all sorts of protocols on how to prevent what Ashley is talking about from happening. And by all estimations, this cop seems like he's following those things. He's not going down the rabbit hole. What do you think?
Oh, absolutely. But I got to say this. I don't care if you're 88 or 8 years old. The rules of evidence still apply. And when Millie said that I heard or someone told me that she was given to chicken with a knife down her throat, or suggesting that, I mean, how in God's name is that not objectionable unless she observed it? If she didn't observe it, or it wasn't something the mother said to her, that should be stricken.
Yeah, that is surprising, Gene, and I guess we'll find out whether or not the defense, you know, what the defense's idea is here, because the defense clearly knows what they're doing. Real quick, Ashley, on the point of the defense, because Gene and myself talked about this last week, it is surprising to me, shocking, and as this case is developing more, even more shocking, that one defense lawyer, one defense team is representing 2 defendants in that courtroom that have differing defenses and differing charges. So that husband's getting a raw deal here, in my opinion. Oh,
I got to tell you, Bob. Yeah, the husband's being thrown under the bus by being represented by the same attorney or the same even public defender's office as the wife in this case. It blows my mind. This is a simple phone call to the Georgia Public Defenders Council to get what is called a conflict defender out there to make sure that the husband's conflicting interests in this case are protected and that his constitutional rights are protected. I don't know what's going on, but clearly there was a conflict with the prosecution in this case, and it wasn't an issue for the state to get 2 amazing prosecutors from different counties to come in and substitute in. Georgia Public Defenders Council shouldn't have been an issue on this. So I'm not really sure. I don't know if this is going to be an issue on appeal. I should hope it would be for, you know, Mr. Rosenbaum in this case, but we'll have to see what's going on.
Yeah, and great point. And Gene, you know, you don't want to go in with co-defendants and having an antagonistic defense. I get that. But at a certain point in time, all the charges for him rely upon his knowledge of what she was doing. And as a defense lawyer, I would be getting up there saying, just like the school was fooled, just like the neighbors were fooled, just like the doctors were fooled, just like everyone else that came into contact were fooled, so was he. These events were occurring when he was not present. He had no idea, and he was believing the lies of this very sophisticated person who, by the way, is going to law school, is not a dummy. That would be the argument that you would imagine his lawyer would be making. Or in the alternative, Gene, sorry to go on, that if you were to find, ladies and gentlemen of the jury, that she did these things, she did them under the radar and he didn't know about it. But that's not happening here. That lawyer can't do that.
That's a great point. But you know whom else I blame? The judge. I had a drug case where the defendant was willing to waive any conflict with the defense attorney, but I still made a motion with the court because under, you know, U.S. Federal Circuit, Fourth Circuit law, the judge can say, you know what? I don't care if you're waiving a conflict. I don't want one attorney representing 2 people with divergent defenses.
Yeah, it's a basic thing. And listen to this Gene Rossi, man. He's bringing the heat from all sorts of circuits. You can't beat this guy. And Gene, just for the record, so it's clear, our chatters have spoken. Nobody wanted to make the deal. Nobody wanted to say whether or not I should abandon you for Ashley, except one person said, kind of like use an analogy, why would you leave an A team? So I'll guess that that's one vote. I'll throw that as a vote in favor of you. Gene Rossi, you're still going to be my bestie, but she's going to be backup bestie. Okay, listen, guys, let's have a little fun here at the Law and Crime Network. Millie's counselor also is going to be was a very relevant witness in this case. Let's listen to a little bit of what she had to say, because I think it's going to be pivotal in what the prosecution's going to do in summation. Welcome back. Okay, so we're going over the Rosenbaum case. They're at lunch break right now, so it gives us a great opportunity to talk to Ashley and Gene about the most important parts of the testimony. Gene, while we were on break, I asked, is there anything that you're interested in discussing? Now, we had previously been talking about this idea that there's only one lawyer representing two defendants in this case, and that to me, and I think to my colleagues here, that the second lawyer, if there were one for the husband, could have a defense that the first lawyer for Jennifer can't raise, and that, to use Ashley's term, he's getting thrown under the bus. Gene, then we listened to the counselor talking about Millie's, or Laila's statements, or Millie's statements, I forget which one, of the children. It was coming out, and we were asking the question, how legally is this allowed? Because it's really rank hearsay without an exception. And then you brought up a very powerful point, going back to the idea of representing two different defendants and potentially, Gene, maybe a separate trial, is that the husband likes that testimony. That's good testimony for the husband that the counselor gave, but bad for Jennifer. Thoughts?
Right, and this is the problem of having one witness represent two people, a couple, because if I were representing the husband and Ann McCullough got on the stand and had all this hearsay against the wife, go for it, let it all in. Because all it does is it protects and insulates my client from the ultimate decision that she murdered Laila and the husband had nothing to do with it.
Yeah, and what do you think about that, Ashley? Do you agree that that testimony helps the husband? And if so, like, how does the defense lawyer now, who's representing Jennifer and him, get up there and make the argument that testimony of that counselor was really bad for Jennifer, but really good for my other client, the husband?
Well, that's the exact problem here, Bob. I mean, they can't make that argument. And I don't know if this is a situation of stand by your woman, in that he's saying, okay, look, I realize there may be a conflict of interest. I'm hoping somebody at the public defender's office at least explained that to him. If they didn't, we got serious problems. And even if he was saying, like Gene was saying with one of his former clients, they're willing to waive that. The judge should not have allowed this to happen in the first place. So even if, when you're representing somebody and they're a defendant and they've got a conflict of interest and they have, a relationship with their co-defendant and they really don't want to, use or throw any sort of guilt their way in order to, help themselves, sometimes you have to advise them, hey, look, this is the best defense we have. It's kind of the only route we can go. And if this is the case where he's saying, no, I don't want to do that, at the end of the day, you do have to listen to what your client wants because it is their case.
Gene, Ashley is really tearing it up here. I'm not going to lie to you, but I'll add one thing. As the lawyer, I would say I refuse to represent both of you. You either get another lawyer or I'm out.
Absolutely. I mean, there's blame placed on a lot of people. And the more I think about it, I think this is going to be an issue on appeal. Mm-hmm. And it's like one of those other cases, the 8-ball case.
Yeah, Gene, I'm sorry to cut you off. It's going to be something that's going to come up in appeal, and it may have developed during the course of the trial, but may have fundamentally affected the defendant's rights. We got to go to a short break. We'll be right back. Stick with us. All right, welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be with you at 3 o'clock this afternoon. Got great guests and great trials. Don't forget that we got this Grant Amato case coming up. It's a death penalty case. Killed his mom, allegedly, his dad, allegedly, and his brother, allegedly. And part of the motive in this case is that he stole $200,000 to do, of all things, well, pay for a cam girl out of Bulgaria. And that's the prosecution's theory as to why those three folks you see on your screen right there are dead and why he is on trial right now, at least part of the reason. We're covering the Rosenbaum case, too. We've got some great analysis here from both Ashley and Gene. It's really been a riveting case here, and the prosecution seems to be taking nick after nick after nick and piling on the evidence in their favor in what was originally a very contested case. Part of that case involved the ER doctor doctor that treated Laila. Let's take a look. Well, guys, I mean, another compelling witness, Ashley. First of all, he's talking about all of the bruising that is going on in the child's body, the chest, the pelvis, the back, from top to bottom. Does a great job at indicating that these are not from resuscitative efforts, calling one of the fractures when he did that bone scan a nightstick fracture. They were in odd locations and not locations that are consistent with just an accident that a child gets into. Obviously, is going to be compelling testimony, not to mention the fact those jurors are seeing pictures we're not.
Right. And just to imagine, this ER doctor just testified to the fact that he's seen over 100,000 patients. For top to bottom bruising on a 2-year-old child to really stand out to him enough to cause him to do something out of the ordinary, which is to order a bone survey in this case to see if there's any latent fractures or any other injuries that are healing. And he's talking about a defensive wound on this little girl's arm. He's saying, like, look, I'll admit, little kids, fall down and they hit their head and they get bumps and bruises all the time. But you've got bruises top to bottom all over her back, defensive fractures, it looks like in this case. That's not normal. And for that to stand out to this experienced ER doctor says a lot about this case.
Yeah, absolutely. Very good point, Gene. I was just wondering, and it's just, again, I don't know what the rules of evidence are there. Actually, we have an expert right here. But nevertheless, my question became, he's actually giving expert opinion. He's going beyond just the facts of what he did when he says, in his opinion, these were not resuscitative efforts. Rather, they were blunt force trauma injuries. But nevertheless, compelling testimony. I don't see a big problem with that evidentially, do you?
Well, no. If they noticed him up as an expert, there absolutely is no problem. But even if they did not, it's based on his training experience. I don't know if he said 100,000. I thought he said 100, but he's seen a lot of darn patients. So based on his experience, he can make conclusions.
Yeah, and I agree with Ashley. After seeing 100,000, that's the number that he gave. The fact that he would have this bone survey done confirms to the jury when the prosecutor says this experienced doctor felt that it was so suspicious that he went and had this test done, really is very, very good for the prosecution. And he's not the only medical professional that testified in the case. There was an ER nurse that did as well. Let's take a listen. All right, so Ashley, the importance of this time, she explains the mechanism of injuries and how that occurs. I think the ER doc was obviously a very powerful, witness, but what is she lending to the prosecution here?
I think really all she's doing is kind of backing up. I mean, I don't want to say bolstering because, then maybe we'd have some objections there, but she's backing up everything that the ER doctor said in this case. And I think what she's doing is she's kind of putting it in context and for the jury to have something to lean on if they're, a little worried about the ER doctor's testimony. Right. Sometimes when you get doctors in there, you get jurors falling asleep and you get them not paying attention anymore. Science sort of goes over their head. You've got a nurse, she's a little bit more relatable. She's breaking it down in layman's terms. Yeah,
excellent analysis. And by the way, you told me when we were on break that Georgia has adopted the federal rules in terms of the evidential rules?
The Georgia rules of evidence are almost identical to the federal rules of evidence. So as long as they qualify the ER doctor as an expert in this case, which I'm sure that they did, and we just didn't watch it because it's very boring and it was off screen, they should be good to go in his testimony.
Gene, talk to me a little bit based on your experience about kind of what Ashley is alluding to, that is redundancy with witnesses and how you got to be careful, but by the same token, it can be very good to support and back up one another, but you don't want to put too many witnesses on to say the same thing because you get that blown in your face too.
I'm glad Ashley mentioned the federal rules of evidence. Rule 403 is the famous unduly prejudicial rule. And you can keep things out you can keep out evidence that is relevant if it's cumulative.
Right.
And if you called a third witness in addition to this nurse and the ER doctor, then I would object that it's cumulative. They've heard enough. It corroborates, the second witness corroborates the first, but then the third or fourth witness would be too much, as they say, cumulative.
So, Gene, evidence that's relevant may be excluded if it would create undue confusion with the jury, or if it would be cumulative. I mean, it's not just cumulative. There's a number of different reasons under 403. Yeah. Or sometimes, the one I've always found interesting, at least in Jersey, is if the prejudicial effect outweighs its probative value, which requires the court to go into a balancing decision as to whether that could be excluded. So, I mean, have you ever had one of those where I've had cases where the judge is like, it's really, really relevant, argument, but I'm banning it under Evidence Rule 403 because I think it could lead to undue confusion with the jury. And I'm like, well, how?
Exactly. How can relevant evidence ever be confusing to the jury? But I agree. I have had cases where this has come up. Obviously, it's a pretrial argument that you make, or you do it outside of the presence of the jury once the objection has been made. And sometimes when, as a defense attorney, you got some real bad facts, you don't want the prosecution throwing up witness 1, 2, 3, and 4 that are all saying the same thing. And that's all the jury's going to remember, because jurors remember what they hear repeatedly.
Yes.
Just like
so
we do in
when you're a
advertising.
defense lawyer, you take out that 403 flag and you throw it. Judge, please save us here. We need a break. We've had too much of this compelling evidence that's been killing us.
Exactly.
Okay, guys, listen, great to have these guys analyzing this case. They're the best. We're going to take a quick break, and we'll be back on the other end. Stick with us. Okay, so Ashley, what are your thoughts on the first statement that Jennifer is making is being recounted by this officer? What's the prosecution trying to prove here?
Okay, I think the prosecution is trying to show that Jennifer is talking to the police in this case, and that if this is a concocted story, maybe she thinks she's a little bit smarter than they are, and she's trying to explain away that bruising that the ER doctor testified that he saw all over little Laila's body by saying that happened with the CPR. I hit her on the back, I put the butter knife down her throat.
Right.
I was trying all that sort of stuff. So, you've got this fine line that you walk. Is she telling it? Is she innocent and she's telling this story to the police because that's what actually happened? Or does she think she's a little bit smarter than everybody else and thinks, oh my goodness, I need to explain away these bruises that are already there?
Right, Gene, to Ashley's point, my point is that they always feel they have to talk because you don't want to look suspicious. But the other one is, gosh, how many times have we convicted people based upon what they gave to us as statements that we never would have been able to prove the case if they didn't give us a statement? And why? Because they suffered from thinking that they were the smartest guy or the smartest girl in the room.
Oh, self-serving statements, false exculpatories, are priceless. But I got to compliment the defense attorneys a little bit. I now see why they didn't object when the social worker, Ann McCullough, was on the stand and Millie was saying that mom put a knife down her throat, because that's where that came, the butter knife.
Yeah, for sure. Okay, excellent point, Gene. Also in that emergency room, if you can imagine, we had an ER doc, we had a nurse, we have this police officer, was also a foster care worker for the children that was in the ER that was actually listening to the information that Jennifer was giving to the police. Let's take a listen. All right, Gene, Rossi, I got to get my Bianchi up here, okay? I'm listening to this testimony, and here's this awesome witness for dad, the awesome witness for the husband that says she's watching this, and the demeanor of Jennifer, she doesn't know why she can't cry, Jennifer. But the husband was very distraught. He was upset. And then the husband wasn't there, he indicates. He was in the care and custody of Jennifer. These are all extraordinarily defensible points for the defendant, the husband, that cannot be brought out if you're going to properly represent Jennifer. Gene, Rossi, I'm sorry to keep bringing it up, but it's even worse now.
I need a bowl of polenta to calm me down. Okay? But no, on a serious note, I am absolutely livid, Bob. Ashley, too. I am livid. This is a total disgrace, because that husband has a defense. I mean, this witness is fabulous for the husband and horrible for Jennifer, the wife. She can't cry because I have no more tears. Baloney. Her tear ducts are full. They were never used. She was stoic. The reason she's stoic, because it wasn't a surprise that the child is dead. And this is my favorite. When the husband was talking to the investigator, Jennifer was interjecting.
Yeah. Ashley, Gene Rossi has a way. He brought up two foods in one comment. He went to bologna and polenta. He went from the great, polenta to bologna, whatever. Right. But seriously, I want you to put your thinking cap on for me. I know this is really hard. Thread this needle for me now. If you're defending both of these people now, what do you do? Do you get up there and say that if it's her, he didn't know about it? Can you still say that?
This is just unbelievable to me, especially with this witness. I mean, the defense attorney had to know that this witness's testimony was coming and what she was going to say. I can't imagine what their argument is going to be now. I mean, sure, you can get up there. I mean, there's nothing precluding you from getting up and closing argument saying, look, if you do find her guilty, then, you know, say he wasn't there. But I think then you're throwing Jennifer under the bus. You can't do that. You can't split the baby, throw the baby out with the bathwater.
Right. If I were representing, I want to be going that she did it as the lawyer, and he had no idea. He's as much of a victim as she was. Excellent points, though. Listen, you know, one thing that's really important is where is this evidence of choking that went on here? We had an ER nurse that testified in the case. Let's take a listen. Okay, Ashley, I mean, pretty compelling testimony. There was an objection by the defense at some point, I think because they used the qualifying language of an expert, but nevertheless, the prosecutor got out. In your experience, as opposed to in your opinion, have you seen a choking-related incident with a person that doesn't have petechia, they call it bloodshot, eyes, they were not cyanotic or blue in color, they were pale. So a pretty powerful witness for the prosecution. Yeah,
basically she's saying there's nothing here that's consistent with the choking story. And I'm actually surprised, you know, with the defense, they made that objection, but the only thing that they seem to be able to achieve was to have the prosecutor ask the question again, saying, you know, hey, in your experience, is this consistent with someone choking basically on a chicken nugget? She says no again. I think, you know, they kind of hammered it home for the jury. Got a second chance at a second bite of the apple on that.
Yeah, Gene, I noticed that too. She used the expert language, and the judge sustained the objection, and they said in your experience, and she gave her opinion anyway. And what's irrelevant is the opinion. But nevertheless, this nurse also said there was no evidence, physical evidence of anything. She had a clean airway, I think was a term that she used. It wasn't a dirty airway. Pretty compelling witness.
Oh, I think Miss Espinosa is one of the best so far. Absolutely.
Yeah, so, you know, guys, just thoughts real quick on, we're going to be taking a break right now, but I want you to think about what we're, on the other end, what can the defense do right now based upon this cascading set of data that's coming out to the jury? And the question is, that have been asked already in this case, do you advise the defendant to take the stand after all this? But you have to wait to listen to that answer, because we're going to do a break. We're going to come back on the other end with more Ashley and more Gene. Okay, so Ashley, again, this is direct examination. This prosecutor is taking his time and asking these questions, and she just keeps delivering the home run hits here. The injuries all over the face, the varying wounds, and her precision with regard to the fact that they did not occur, many of those wounds, on the day of the incident, but were from previous instances, because I could tell by the coloration and the manner in which the wound was healing. And I loved, she's really good with the jury when she explains, just like when you get, you know, a cut and then you have a scab and it turns brown and the white edges and all that. What do you think? Right.
I think she's very descriptive, and she's setting up a great closing argument for the prosecution. You know, this is a pattern of abuse. These wounds were healing, and I mean, the one slam dunk that she said was, hey, these absolutely did not occur on the date of death, so they were there previously. They were in the pattern of healing. And, you know, prosecution's taking a big risk right now. This is post-lunch. They've dimmed the lights to show some slides. You know, this is nap time for the jury. So if you didn't have Dr. Darisaw on the stand, I think you'd be really risking something here.
Yeah, Gene, I love it, because it's, you know, look, this is a real practical response that Ashley just gave. You know, they're full, their bellies are filled, the lights go down. You got a doctor on the stand, Gene Rossi. It could get like a little bit into that lull of what just happened. But I don't think so with this witness, because I think she just delivers so well.
Yeah, she has a great disposition and a good demeanor. And the thing the one complaint I always have about experts is they have to realize that the whole world is not just watching them. The whole case does not evolve around them. And they get up there and they act a little too uppity for their own good. She doesn't do that.
Yeah, very good point. And you know what, Gene? It is that uppityness, which is where on cross-examination, which I think is my best crosses are with expert witnesses, I get under that skin and pick at that scab that they have, where they think that they are the sole, witnesses of the universe. Definitely a lot of haughty expert witnesses out there. Guys, we're going to do a little work here at the Law and Crime Network. We're going to take a break, and we'll be back with more Law and Crime. Okay, Ashley, I mean, this is really an extensive examination, direct examination, and she's doing a great job of just detailing so many injuries. I'm looking in the chat room, and they're like, poor thing, beaten every day. That's at least what our second jury is coming up with in their thoughts and listening to this testimony. What do you think?
I couldn't agree more. I mean, basically what she's describing is a pattern of abuse. You know, she's saying that these injuries not only were all healing at different rates, they definitely couldn't have been, she didn't get the injuries on the day of her death. Mm-hmm. And each injury, each abrasion is healing on a different timeline. So clearly she's getting these getting injuries consistently, and they're healing at different rates. So I think that's going to be the main part of her testimony that we're going to take away.
Yeah, Gene, and I think very powerful, testimony, especially when you couple it with the injuries that were on the other daughter, just really painting a horrible picture of these two kids' lives.
Oh, absolutely. I want to go to something you gave us during the break, the homework. You know, how you defend this.
Yeah.
And I got to tell you this. I would not call the wife. I would call the husband. And I call the husband for two reasons. One, I think he's got a defense. And number two, he could possibly help his wife by saying, I observed her when I left that day. Laila was sleeping. She tried to treat the daughter well. Something to help the wife. So calling the husband would be a possible twofer to help himself and also to help the wife, mitigate what appears to be a mother who's just out of control.
Yeah, Gene, thank you for answering that. I just think it's dangerous for the husband, in my opinion, to get up there, because as a defense lawyer, I want to be hammering. You didn't hear anything that connects him to knowing anything about this. She fooled everyone else. She fooled him. But being forced to do that because one lawyer is representing two defendants is problematic in my mind. We're going to go to break. We'll be right back.